former Fulton County District Attorney and Sheriff.
Formerly a judge, and he knows a little bit about how these things go.
From Mohawk Valley, legal eagle, lawman.
He is the Sheriff of Fulton County, New York. Just such an amazing guy.
This is the Rich Giardino Show, where the Constitution, crime, and politics meet.
I'm Rich Giardino. You're listening to the Rich Giardino program. This is where crime, the Constitution, and politics meet. Our guest this week is Professor Michael Hutter, who is a professor at Albany Law School. He lectures extensively to judges, prosecutors, defense bar, lawyers, not only in New York, but across the country. He's taught for 48 years at Albany Law School, even when I was there. When I was first starting out, I guess, because I've got that much.
Sounds like you're trying to get your grade changed.
I need that help. I need that help, Professor. But Professor Hutter is going to talk to us today a little bit about the recent Supreme Court decisions. And Mike, the first thing I want to ask you, your different commentators say a decision was handed up, a decision was handed down. Is it handed up or is it handed down, and what does it mean?
Handed down. That's the formal word that's been used for literally hundreds of years.
Okay.
Starting with the English common law.
And how do cases, a federal case obviously can get to the Supreme Court, but how would a state case, like President Trump's prosecution in New York City, how does that go through the system to get selected to be heard by the Supreme Court?
Well, the Supreme Court clearly can take cases from the highest state court. Generally, they're looking for something that presents a federal constitutional issue, or maybe the state applied federal statutory law. They will not review pure state issues. It's really outside their jurisdiction. But when a case goes to the Supreme Court, say the New York Court of Appeals renders a ruling on gun control, the way that gets to the Supreme Court is that the lawyer for the petitioner, the losing party, will make what's called a application for a writ of certiorari, the Latin to be certain, in which they ask the Supreme Court, we have a good case under the law, we think it has national implications, and you should hear it. And the parties submit papers in support and in opposition. And generally the court rules on cert applications within three months of their filing. It takes 4 justices to grant cert. And a lot of times there's a lot of jockeying for trying to get a 4th justice. But also, it's also important to note that some justices may like to grant cert, but the case does not present good facts. And they rather wait for a good fact pattern to show what they really believe in. So there is a lot of give and take and thought process with the cert application. Again, they don't grant that many cert applications, but when you look at the statistics, a lot of the applications are junk that lawyers they want to go to the Supreme Court. They want to tell their client, I took it all the way to the Supreme Court, or a lot of prisoner writs. But the court really takes their job very seriously with writs of certiorari.
And Professor, when they decide to take the case, by taking it, they're not saying the person necessarily has standing. That'll be a ruling in their decision that they hand down. So a lot of people don't understand, like recently there were several cases, and a couple of them were that they upheld the lower court and sent it back down only because there wasn't standing. And I think people get confused. So when the headline says court allows the abortion pill to remain in use, what does that mean when they say the reason they're doing it is because the party did not have standing to bring the case before them?
Well, it's a tradition that started with the English common law with respect to judges ruling on abstract issues outside of a dispute. And so the people couldn't ask the Supreme Court or any court, please rule on this. You had to bring a lawsuit. And then it really crystallized to make sure that the person then who's bringing that lawsuit really has standing in the sense that they've been aggrieved by the ruling they have a real interest in the result, and they will pursue it in earnestness. The courts just don't want anyone at the drop of a hat to make a federal case out of it when they have really no interest in it. They're afraid now of people bringing a lawsuit, then losing interest in it, or the issues not being presented very well, cogently. So the standing doctrine started out in good faith by the courts. We really want to hear cases that are heard by someone. And the Supreme Court back in the 60s really changed things when they went to issues EPA. They wanted to, people wanted the EPA to step in and bar certain parks being built out in Colorado. And, well, who were they? Well, they were just people who had an interest in the environment. And that was deemed to be too general. But then the court said, if the people went out there and visited that area, then they'd have standing. So it became a very murky area. And now in the last couple of years, I think the cynic can say if the Supreme Court doesn't want to hear a case that presents really good issues because they're not sure of the outcome, they have the votes, they will invoke standing to evade responsibility. So that's how they've gotten out of a lot of jams with respect to reapportionment, several abortion type issues, various different things that they feel that we should not get involved in. And it creates problems. And one of the things, I teach a course in federal jurisdiction. And one of the things that I teach is that when you are thinking about a case in federal court or even state court, obviously you want a case that has a lot of merit, but you also got to make sure you have the right party to pursue it, that the person really is harmed. So a lot of these civil rights cases are challenging major policy issues that the parties are now trying to seek who would be the proper party to pursue this. You might be concerned about Lake George, the pollution, and you go up there, you boat a lot, and now you're concerned about, gee, they're bringing in this new pesticide, going to destroy everything. Who can bring that action? Does it have to be property owners, boat owners? Can you and I, who maybe go up there every now and then, have standing? It's something that lawyers have to work out. And what they do a lot of times is they name a lot of people just to make sure they have the right person.
So they get somebody. So in the last month, there's been several decisions that I wanted to ask you briefly about, just to explain so people understand. I think the first one is the January 6th cases, because the first thing is that wasn't all January 6th cases. That was a limited number of cases involving a particular section, correct?
Yes.
Okay.
Yes. What's fascinating is that, again, the media in their rush for trying to cover this without really thinking it through, where they said, oh, all the convictions have been reversed. No, not really. The case that was handled by the Supreme Court involved a police officer, state of Pennsylvania, who had marched into the Capitol, and he was accused of obstructing official proceedings. And although his intent really was, I guess, it looked like he wanted to prevent Vice President Pence from voting in the Electoral College. And they charged him now with, well, you were trying to prevent Vice President Pence from doing his official job. And the lower court said, yep, that's a violation of federal law. Now, this is nothing with the violence, destruction of property. He was just en masse walking in to the Capitol and scaring away Vice President Pence and a lot of the Electoral College voters. The Supreme Court, in a 6-3 decision, and it's interesting that the lineup on this is that, wait a minute, the statute is very narrow. The statute says obstruction, but based upon interpretation, what it really meant is obstruction by reason of destroying evidence, concealing evidence. So it's a very limited ruling. And they found, at least on the facts before it, this trooper, a police officer, there was nothing that we have in the record that showed he was trying to destroy evidence. So what they did is that they then sent it back down to the lower court to look at, well, exactly what was he doing? And this is where the concurring opinion by Justice Brown, who's considered very liberal, where Justice Brown said, wait a minute, let's look at this statute. We just can't just apply it willy-nilly. She went along basically with the majority, but then said and really fleshed out what the majority was saying. If in fact this police officer had the desire and maybe was able to get into the electoral college, he would have to basically destroy evidence. So that would make it a prosecutable offense. But again, she said the facts here don't really show that most of those people involved in January 6th can be charged with the statute that they were apparently was being considered. So still a lot to be fleshed out with those charges. And I think it's probably, and you know, Richard, from your days as a DA, DAs get accused of overcharging. And that may be what happened here. They were so anxious to get at and show that we're serious about, we can't have this making the U.S. look like a banana republic. We got to do something. And they never really thought it through.
Yeah. And so it affects a couple hundred cases, my reading was so far. And basically being present and not displaying an intent or a provable intent and not actually doing anything. If they displayed an intent or present, it might be an attempt, right? Because they didn't destroy anything.
Exactly.
But when the media gets it, they don't understand a lot of the time. Then there was a Second Amendment case that dealt, I think, with the magazines and how many bullets you can have in them, correct? Tell us about that one.
Well, they had interesting two gun issues. Well, first of all, just for prefacing it, there's still a lot of fallout from the Supreme Court's decision in 2022, where it struck down New York's concealed carry weapon statute. And the case was called the Bruin case.
Yep.
And the basis for the ruling was that we look at the Second Amendment, which guarantees the right to bear arms, and it's got to be interpreted in light of the history of the Second Amendment, which was enacted in 1791. And in Bruin, the court said there was nothing back then that would prohibit what this statute does. So therefore, it's got to be unconstitutional. But then there was some blowback from that. And, well, what are we really looking at? And I've always looked at Bruin as, do you mean that you can only control muskets and sabers? And which is, obviously, it can't be. So the Supreme Court initially, with the domestic violence case, then I'll get to the magazine one. In Texas, a domestic violence serial violator was charged with possessing a firearm. And there's a statute that says if you're convicted domestic violence, show any tendency to commit violence upon your partner, that's a violation. You can be barred from having guns. Now that was upheld, interestingly, by the Supreme Court by 8-1. Even the liberal judges, even the conservative judges said, well, we're going to look at this in light of what we did in Bruin, but we got to look at it a little bit more realistically. Not what was exactly going on in 1791, but comparable situations. And they found through exhaustive history that back in 1791 and before that, states were limiting guns, the availability of guns, to violent offenders, which I never knew until I read that decision. Never learned that in American history in college.
So it's interesting, and that's and I thought that was a great call, and I thought that when I see it, and I've had people threaten to shoot me, by the way, and mostly as a sheriff, and less as a judge, and frequently as a DA, threatened to kill me violently. But I used to be opposed to the ERPO law, where they could see somebody's guns, the red flag law, because I thought parts that are unconstitutional are there's no medical testimony. It's just me saying, hey, he threatened me. But until somebody threatens you, then you have a different perspective on laws, you know?
Oh,
And I
sure.
was like, yep, I see the reasoning. I don't want this guy to have a gun. I don't need a doctor to tell me that he threatened to shoot me. He either threatened to shoot me, which he did on tape, or he didn't. So it's interesting. So then the other amendment, Second Amendment case was the ammunition magazines, correct?
Yes, and this was a very, very narrow ruling. And a lot of people were wondering why the Supreme Court granted cert, but I think it was trying to show that we're not a court that just wants guns, guns, guns. That we do look at this on a case-by-case basis, and we realize that there can be reasonable restrictions. The defendant was charged with basically that bump stock type of weapon, and charged with violating a federal statute, a regulation that didn't really provide, that apparently governed it. But the Supreme Court, again, looked at it. It doesn't do that. It just doesn't do that. Again, it's overreaching. And what it really did is it slapped down, if you want to do this, and the court indicated that, yeah, you can put restrictions like that, but do it, if you're going to do it by regulation, make sure now that there's input by everyone, make sure it's clear, and make sure there's power, that Congress has said that various agencies can control this. And that's all they're doing. And again, what they wanted, I think, here is that this is an important issue. The people should be heard on it, not some bureaucrat who decides, well, this is really great, fits my political philosophy. But that's
funny.
Go ahead. I'm
it's
sorry.
Funny because what the press did was it was Donald Trump's executive order. And so the press missed the whole point. They were just saying it can be done. It just can't be done that way. It can't be done with an executive order. Similar to when Andrew Cuomo was trying to tell the police, you got to count people in people's houses. And if there's 10 or more, you got to take action. But he doesn't control local police in the same sense he controls the ABC board, the SLA, or public health. So that my argument would be, so it's almost an executive action that would have required legislation. So again, they didn't say that it's going to remain that way forever. They said the legislature or Congress has to act in that particular case, or state law has to.
Yeah, and that was a common theme actually for the last 2 years with the Roberts Court, is making sure that when legislation or regulations are passed, that the legislature really wanted this, and they don't want bureaucrats unhinged in interpreting and applying various laws to suit their own political leanings. They want let the legislature spell it out, and that's all that the gun control that machine gun case was doing.
Yeah. So we started out talking about standing and not, and then let's talk about the abortion pill case, because everybody, again, the media just misinterprets it and they give such a false impression. So the Supreme Court wasn't saying, hey, abortion's okay. What they were saying is the individuals who brought the case really didn't have standing, as you had
Correct.
told everyone in the beginning. So, but the practical effect on that is that pill can be used to cause abortions, medically induced abortions. It doesn't mean that it's always going to be able to be used. It's going to have to be, the people who challenged it didn't have standing.
Correct.
So the court didn't say, is this a good thing to do or a bad thing? They didn't even get that far. They just said, hey, it was an association of doctors and something else who brought the lawsuit.
Yeah. What was interesting is that, again, one of the more conservative judges on the court, Judge Kavanaugh, wrote the opinion, and he starts out by saying, quote, "What's it to you?" i.e. is pointing out, look, where's your standing? And what he pointed out is that the doctors who brought this action were committed anti-abortionists. They're not quacks. They were really true to their beliefs. They thought that abortion is wrong, and they thought that the availability of this drug, which the FDA now had relaxed and removed a lot of the conditions, now makes it a generic drug almost, that this is going to create more abortions and there's health risks with this drug. And that was their catch. But what the Supreme Court said is that doctors, you're not being harmed by this. Now, to the extent that it shows you what lawyers will go to get standing, they wanted this case to be heard. They were saying that the doctors are saying that, well, what's going to happen is that we're going to get called in at the last minute on an emergency created by a woman ingesting this drug, and it's going to impact our practice. And therefore, we get standing. And Kavanaugh said, well, it's too speculative. And what he speculated, well, then as to speculation, the question now is what we talked about initially, Richard, is who's the proper plaintiff in this? It might be maybe the manufacturer of the pill, but obviously then they're making a lot of money on this. They're not going to challenge any of this.
So my question for you with regard to that, though, it would be, let's say this, if the legislation or the order said, you doctor have to prescribe it if somebody asks, they might have standing then because it might be against their religious belief. And that would be a good argument, right? I got to just say, this is the Rich Giardino Show. You're listening to Professor Michael Hutter from Albany Law School. He's been a professor over 48 years at the law school. He lectures extensively to lawyers and bar associations, to judges, to district attorneys and defense attorneys. And we're just reviewing some of the recent decisions in the, well, let's say late spring and the summer of 2024 with the Supreme Court. Well, one more case that I think has gotten so much publicity. And again, it's so frustrating when I try to explain to people, even some lawyers that I disagree with, that it's not saying the presidential immunity case. So my simple understanding is this. They said if it's an official act that a president does in line of duty, then he's protected. If it's purely personal, then he's not. And it says if it's in the middle between official and personal, then it's up to the court to have a hearing and determine which way it falls. Is that kind of what can you explain this one in a nutshell for people?
Yeah, I think here we start out with it again, a very broadly based indictment by the special prosecutor, where President Trump is charged now with basically inciting a riot, among other things, or all sorts of other different things. And what the Supreme Court did then is, as you're saying, and it really kind of, the Solomonic type wisdom in trying to figure out the best way to go. It initially said, and no one, at least, well, maybe some of the press don't even acknowledge it. He initially said that there are certain acts that the president can never be criminally charged on. The core functions of the president, even granting pardons, executing treaties. No, that's just off base. And the press now says, well, they gave him complete immunity. But they realize that that's ridiculous. You can't charge a president when he executes signs a treaty. It's ridiculous. But then the next part then was, well, what about something that's not core, but it's something done officially, i.e. he has maybe the authority as president to do this. And this is where the Supreme Court now created a real muddle. They make the distinction now between official and unofficial acts engaged in by the president. Now, what does that mean? And they don't give us much guidance other than saying to us mere mortals, it's difficult. It's difficult to figure this out. But then Chief Judge Roberts in his decision puts forth as, well, there are going to be certain things that are palpably improper. President shooting, so on, like that. But other things, he says, it's going to be a little bit more difficult. And that's where he then gave some guidance by going through a couple of things. For example, one of the charges involved President Trump that he was leveraging the Justice Department authority to convince states that the election was fraudulent in their state, trying to get DOJ to get involved. Is that official or unofficial? Well, again, most people will say you flip a coin. But what he said is that this got to go back now for determination. You know, how much involvement was the president involved in this? Even the efforts now he was accused of trying to intimidate Vice President Pence. You can't sign this. Is that official? Or is that unofficial? Now that to me sounded to me like more like unofficial. I don't think the president has any authority at all in that area. But the Supreme Court said could be. So we can go through a lot more of these charges. But what's going to happen now is that it's a very gray area. And that's going to be creating the problems. We have no case law on this that tells us the difference. It's going to have to all be developed. And what the problem is, again, is that the media and taking the language of the dissenters, we created a king. We haven't created a king. We created a king for core activity, sure. But even the dissenters didn't say that, disagreed with that. But the media picks up on that. So what they're concerned about is that almost anything outside the core can be indictable. And that's going to, I think, in my view, to make that automatically potential after a president leaves office, that's going to really tamper his or her enthusiasm for taking stuff. I mean, if I do this, I can be indicted and spend my retirement years, my pension in Leavenworth. I'm not going to do it. So it can be that chilling effect. But it's again, the problem is, I think it was a nice compromise. The problem is that the politicized nature of our society today. You're either for Trump or you're against Trump. And that's what's creating the problem publicly, and the media won't fess up to that. They simply will not acknowledge that.
Well, I agree with you. I just want to say again, you're listening to Professor Michael Hutter from Albany Law School, and we're reviewing the United States Supreme Court cases that recently were handed down by the court. Please listen to our program, share and like on Spotify, X, Apple, YouTube, and any other platforms that have excellent programs and mine. Afterwards, stick around because we'll be playing a short, brief interview I had with Chris Salcido of Newsmax last week, and that was an interesting conversation. And please stick around. That's a 5 or 10 minute clip. Professor, and I don't want to put you in a bad spot because of your position as a professor and trying to be a straight shooter down the line. Have things gotten more political? Or is it just that it was always political? Because there are always both sides arguing, that's a political decision. They only did it because they're Republicans or Dems. Has it gotten more political, or is it just that it's because of the way now we have media 24/7 outlets telling us all this stuff that it just seems more political? I guess that's kind of what I'm stumbling around.
All decisions ultimately are political because they're going to favor one party or the other, or a view of one side contrary to another side. So everything's always going to be political. And I think Chief Judge Earl Warren said, we read newspapers and they know what's going on. And that may have generated a lot of concern is, are they doing this politically to support one side? Again, without waterboarding justices and force them, why did you vote that way? I think we have to take them at face value that they are legitimately trying to interpret the Constitution to do what they think the Constitution requires. The problem, again, though, is that people don't like that. If the Supreme Court comes out with a perfectly cogent decision, wonderfully reasoned, but it offends someone's, well, wait a minute, we want to be able to do that. All of a sudden, it's a lawless court. And that's the problem. That's the problem. I think the court this year, Chief Judge Roberts, in my view, in my estimation, has done a wonderful job in maintaining the legitimacy of the court and showing that, wait a minute, we're not in a political court. And a lot of his decisions point that out, that the gun control case, and then the abortion pill case, the homelessness case, they are pretty good decisions. And it shows in many respects, it is a relatively moderate court, maybe moderately conservative, but it's not an alt-right court. But again, the liberals are really liberals, progressives. It's their way or the highway, and that's what's driving the debate.
It's interesting because as a judge, I looked at the case, I looked at the facts, and I sat in some civil, I was acting supreme, but more criminal. But I always looked and said, where's justice? What should be happening with this case? And so I think there's pressures on judges that you want to be true to your oath, you want to be true to the Constitution, but you want to see that people get a fair shake and it's a fair result. So I found that when I would have split decisions, if I felt that somebody was not treated right and shouldn't have been in that position, I would say, well, 4 cases say this, 4 cases say that. I can go either way. I want to go this way because I think that is just. And I really think that that's what the system. I think that I give everyone the benefit of the doubt that whether you're liberal, whether you're conservative, whether you're Republican, Democrat, I think in your mind you want to do what's right. It's just that we all disagree. We don't all agree necessarily what's right. Same thing with candidates. I think everyone starts out with these lofty goals and dreams and want what's right, and then I honestly think the system corrupts them with money. You're here now. I don't know if you heard what happened today. We'll know when this show is played and shown. We'll know if President Biden stepped down or if he's still running for president. But today they said $90 million are being withheld from donors to the Democrats and President Biden. And they said if he steps down, they'll release the money. So that tells us that, it's driven by money, which we all know.
Yep.
But it's nothing clearer than the threat of we're going to withhold money. And again, that case is so interesting. I feel, and I've told people, I've never seen our country this divided. And I think that what happens is the extremists on right and left drive the airtime on the media. They drive, everything is 24/7, and moderate people in the middle, which I think is the greatest percentage, get turned off and they tune out. And so then they don't even pay attention. I have very intelligent friends and I say, are you watching what's going on? No, I get sick of listening to the news because it's so skewed. And I don't think there's a lot of places that people can go and say, well, that's pretty fair, or that's fair, or this is honest news. I mean, Fox News was saying, look at President Biden the last 3 months. Oh, he doesn't know what he's doing. MSNBC and CNN was, oh, it's fake news. The Republicans are showing only clips. This is all made up. And then on the night of the debate, I went to CNN and MSNBC, and within 5 minutes, they were both calling for his head and telling him to resign. And it's like, I personally, it's a little bit off our topic, but I think he was set up by either people around him or by somebody, one of the Democrats who were giving him advice to see if he could do this, then we can keep him. If he can't, we got to get rid of him sooner rather than later.
I'd agree with that assessment.
Yeah.
And again, what you're saying about that, the justice, one of my favorite judges is a judge from your area. Well, actually, sat in Montgomery County, Jim White, the former DA, and then Jim. Yeah. Where he basically, when he convened court, he said, we're talking justice here. Forget about politics. And he was just such a great judge. And again, your area has produced some terrific judges.
Both Judge Elise's,
Dick Elise,
who were the Supreme, Dick Elise, got a lot of great judges out of this area. Too many to mention. I'll insult somebody. But yeah, and what's nice about the judiciary, there is a spectrum. There's a wide range of opinions and views. And I think most people I worked with as a judge wanted to do the right thing. The question is, the right thing is what, in their eyes. And so I don't question their motives. I question sometimes their logic or sometimes their political position, but not their motives. I think when they do it, they're trying to do what they think is right. Whether I agree with it or not doesn't matter. And I think our system, and you've been around a little bit longer than me, but not much, but I think our system is still one of the best systems in the world. And
I agree.
And I think when you don't like the result, it even makes it more important that you support that result. Because when you like the result, it's easy to say, oh yeah, that was a good decision. That was a good verdict. I found trying cases as a DA and a judge that sometimes the cases you think were going to be not guilties were guilties, and other times you thought it was going to be guilty and it was a not guilty. You know, it's the jurors see things we don't see. I think CSI, NCIC, TV, I think body cameras have all altered what they expect. So if there's no body camera, then it didn't happen or the police are lying. You know, it went from the old days where, you know, it was fascinating because when I started in trial tactics, we were told you don't want teachers, you don't want social workers. Then when I became a judge, less a DA, more a judge, teachers and social workers would be on the panel and they were dealing with kids who wouldn't listen, parents who were going to sue them and everything. And they became more conservative and less feel good liberal. So pendulum swings. I'm hoping our country comes back to the center. And I hope that, do you think they'll try and stack the Supreme Court? And when I say stack the Supreme Court, and when President Roosevelt was president in the 40s, there was right in the 40s, Professor,
Yes.
I think there was a call to add more judges to the Supreme Court, and that would water it down, and he could appoint more judges. Last year, they started talking about that same thing. We need more judges because they weren't happy with the decisions. So, do you think that a move to add judges would succeed?
There's certainly a distinct vocal group that wants that, but to President Biden's credit, and a lawyer, he has not really pushed that at all. He realizes it's a bad idea. Then that would clearly show the court is political.
Yep.
And no one wants that. I think, again, you have your hardcore partisans, but I don't think that'll ever happen.
Hey, Professor Hutter, thank you for spending some time with us. I really appreciate it.
Oh, it's my pleasure. Love to
in
come back on
future-
something else, Rich.
Yeah,
Richard.
and we got a lot of things going on in the law, you know, so there's always something to come back to. Thank you for your time and thank you for your experience and your knowledge. It's good because I want to use the podcast so that people can learn and educate themselves and not have a 2-minute soundbite on the national news that says, "Oh, the Supreme Court ruled that the abortion pill is great." No, they ruled that there's no standing. And right now, the abortion pill is still going to be used. You know, there's so much confusion. Thank you for clearing up a lot for us. Thanks, Professor.
My pleasure again. Thank you.
Hey, at the completion of today's show, we have a Giardino Extra. It's the interview that Chris Salcida and I had on Newsmax on July 4th with the Constitution, the Supreme Court, President Trump, and impending issues. Please stand by and listen to that short interview. I think you'll find it interesting. Thank you.
In the meantime, folks, crooked Judge Juan Merchan has delayed President Trump's sentencing to mid-September. But there was one part of the announcement that caught our eye. Merchan wrote, the court will convene that day, quote, if such an event is still necessary, end quote. The delay was implemented so Trump can appeal the case in light of the Supreme Court's immunity ruling. Some say that could be a positive for President Trump. On the other hand, the timing of all of this raising a lot of questions, as the sentencing date would be very, very close to the election. For more, let's bring in former New York State judge, former prosecutor, and host of the Rich Giardino Show, Rich Giardino. Good to see you, sir. The focus on Merchan's lament, if such a thing is necessary, to me, that suggests that Trump's appeal could be heard before sentencing, and Merchan knows how crooked his case was from the jump, and it will likely be overturned. I'm no lawyer, so let me just ask you, is it possible an appeals court could hear this case before the sentencing date?
No, I think what Merchan was saying, I agree with you. It's going to be reversed on appeal, whether it's the state court that does it or the federal court. But what Merchan is saying, if necessary, and I think what he means is if he doesn't set aside the case based on the immunity decision, then there will be a sentencing in September. So he's not talking about the appeal. He's talking about his actions, because after a conviction in New York State, you have a right to ask the judge to set aside the verdict based on the law or the evidence. And what's interesting is, since Trump's been convicted, the law changed on immunity. So that's going to set the judge up with an interesting question.
Well, to this point, Mr. Merchan has shown no ethics whatsoever. What do you think? Do you actually think that he would actually look at the Supreme Court ruling, that he would be painted into a corner, that he had no other choice than to undo this?
Well, speaking from a legal standpoint, I think that he has to review it in a fair way. I don't see that happening. Politically, if you're one of those people that believe this is a political prosecution, what Mershon is going to do is, I would bet he's going to dismiss several counts and say that, well, the immunity applied to this act because it was an official act, but it didn't apply to this act because it was personal. And some of the witnesses that testified, their testimony should be stricken because they were talking about official acts. So I think what he's going to try to do is Solomon-esque, split the baby so he can say, oh, look, I was so fair, dismissed 10 counts. That way he's hoping appellate court looks and says, well, the judge was fair. He reviewed it and he dismissed 10 counts. So it's pretty interesting because when the Supreme Court ruled, they said there's 3 areas: official acts, personal acts, and the inside gray area, which lower courts will have to interpret. They sent it back to the circuit court in the D.C. case. So what they're going to do is Mershon is going to review that center and say, well, this one is personal, this one is official. And he's going to say, maybe this witness testified to something they should not have testified to because it was in the official capacity. That's what I'm betting, Chris. I think.
Well, if Mershon tries to split the baby, I've already got a response teed up for that. Meantime, Rich, the Justice Department, the Injustice Department, I should say, they say they're not going to stop this lawfare against President Trump, even if he wins election. Officials telling the Washington Post that they'll keep on probing all the way up until Inauguration Day if President Trump is the victor. Meanwhile, the 2020 election case is delayed, and the Georgia case is also on hold, and the so-called classified documents case is imploding under government corruption and government illegality. Then there's the Justice Department, the Injustice Department, refusing to hold Attorney General Merrick Garland accountable for defying a lawful congressional subpoena, while Steve Bannon and Peter Navarro are rotting in prison. Rich, why do you think Democrats are so emboldened to continue to abuse our justice system?
Because they can. And it's funny, you call it the injustice system. I refer to it as the just us Department of Justice. So just us. In other words, just us Democrats, just us. We're going to see who gets justice and who doesn't. And what's fascinating to me, Chris, is that all these cases are falling apart before our very eyes. And can you imagine, like Fannie Willis, her special prosecutor ended up going to the White House. What the heck's a special prosecutor going to the White House for when this political case is pending? There's so many issues in all these. And what's funny is, if Biden does step down, and I think, by the way, it's another topic someday, Chris, but they set him up by making him go and do the debate, because as soon as it was over, Joe Scarborough, CNN, this guy, after they spent 2 months saying fake news from Newsmax, fake news from Fox, everybody is showing improper clips to make Joe look like he doesn't know what he's doing. And you see it for your own eyes, and they piled right on him and started demanding his head and that he go. So I think it was a setup, number one. Number two, now the question is, they started all these prosecutions, and if you believe that it's lawfare and it was intended to get rid of Trump as an opponent, now what do they do if Biden's no longer the candidate? You know, it's an interesting setup that they've done.
Well, true, and you're not the only one out there saying that some elements of the Democrat Party set up Joe Biden to be exposed after they spent the last 3.5, 4 years covering for him. Look, I've only got about 35 seconds left, but I want you to comment on this. You're from New York, a place that is ruled, as you know, by majority of self-identified socialists. How do those socialists mark Independence Day? Do they all wear black or what?
For the rest of it, it's a celebration of our independence from Great Britain and from the rule. And people, to know the history, a lot of the Declaration of Independence before the Constitution was because of taxation and unfair. And it's funny because the old white guys said they weren't going to be slaves to Great Britain, yet they all were slave owners. So that's another topic. But it's so fascinating, the history. On my podcast, we talked to a historian who explains that the Sir William Johnson and the Tories and the independence seekers, the opposite of the Tories, had all these issues going on back then. But what struck me was they didn't want to be slaves to England, and they didn't want to be taxed. So it's funny how that worked.
Right. And of course, what does the Democrat Party want to do? They want to enslave us all with high taxes. Rich, it's great to meet you, sir. Rich Giardino, I should say. Thank you very much.
Like and subscribe to The Rich Giardino Show, part of the Elite Influencer Network, wherever you get your podcasts. And we'll see you next time on The Rich Giardino Show, where the Constitution, crime, and politics meet.